Hello. In this clip from our Justia webinar, The Attack on DEI, Safeguarding Corporate DEI Initiatives, Ebony Morris and Valerie Fontenot covered the Supreme Court's decision and the response to the Student for Fair Admissions decision. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So Chief Justice Roberts, his majority opinion, joined in by all of the predominantly conservative justices on the court, found that the admission systems violates the Equal Protection Clause for 3 reasons. First, they do not pass constitutional muster under strict scrutiny, and they fail to comply with the standards that race may never operate as a stereotype or be used as a negative. And Chief Justice Roberts contended that the admission system lacked a logical endpoint as required in Grutter v. Bollinger. If you will recall, Justice O'Connor in the Grutter case indicated that while she agreed with the outcome at the time, she felt that sometime in the future, potentially in the next 20 years, that consideration of race would no longer be needed because society would have advanced far enough that race would not be an issue. Well, lo and behold, almost 20 years to the day in 2023, the decision in Grutter was struck down, particularly regarding the admission systems and their consideration under strict scrutiny. Chief Justice Roberts said the goals of the admission criteria did not establish a compelling interest, and we're going to get to what they do consider a compelling interest in the next slide. However, they found there was an insufficient nexus between racial classification and purported government interest, which I would argue it's not necessarily true, and we'll get into that in a little bit. Can we go to the next slide? Okay, so the standard of review that the court used wasn't necessarily Grutter v. Bollinger or the Fisher case. Rather, they used the Adirondack Construction versus Pena government contractor case that said specifically racial classifications are subject to strict scrutiny, and there are only 2 compelling interests that are permitted to resort to race-based government actions. Number 1, to remedy specific identified instances of past discrimination that violated the Constitution or a statute. And number 2, to avoid imminent risk to human safety in prisons, such as a race riot. So that second one is very specific. And the first one, while specific, I think can be a little bit broader. They also look to the case City of Richmond versus LA Crossing Company, and that was related to a preferential government contract program. And you're going to see that this kind of affects the Small Business Administration. We'll talk about that later. And that particular case specifically said that lessening or ameliorating society discrimination is not a compelling interest to justify race-based state action, because they contended that it would open the door to competing claims for relief by every disadvantaged group. And so, next slide, please, Ebony. They set out, in the opinion, it set out limitations on recognizing that equal protection disallows race from operating as a stereotype. And so for this, it essentially has to consider that if you're considering race, that race operates as a stereotype in the sense that all Black persons would think alike, or all Hispanic persons would think alike, etc. And that's what they're saying. Universities are not permitted to operate on the belief that students, because of their race, express some characteristic minority viewpoint on any issue. And because in their mind, that promotes the exact stereotype from the Equal Protection Clause. And that was their reasoning. There were 2 concurrences, actually 3, I believe. One from Justice Gorsuch, one from Justice Thomas, and then another from Justice Coney Barrett. The one that got discussed the most, of course, was the concurrence by Justice Thomas, particularly when he discusses having a colorblind constitution and his opinion that that was the original interpretation and textual interpretation of a colorblind constitution. And he cites Plessy versus Ferguson for that contention, and you can read the quote here, and it's been provided in the materials. Justice Thomas also particularly stated that school interests are educational and not social. Although if you ask my mom when I was in college, she would probably say that's not necessarily true, but that no form of racial discrimination is helpful to social goals. And he particularly discussed the notion of social progress serving as a guide for invidious motives, and that the social goals of peace and harmony in educational settings were once the reason that provided the basis for university segregation. Next slide. Next, we're going to move on to the dissent of Justice Sonia Sotomayor. She wrote the dissent for the majority of the group. I know Justice Ketanji Brown Jackson's dissent got a lot of discussion. However, she could not participate in the decision, in the dissent in the Harvard case, because she had previously been on the board of the fellows before she became a member of the court. And so she recused herself from that particular case. And because she couldn't write for that one, Justice Sotomayor wrote the opinion for the two cases combined, and Justice Jackson wrote a separate dissent related to the UNC case alone. And we'll get to that one later. Justice Sotomayor and Justice Jackson both had fiery dissents, is what I would say. And they both endorsed the idea that a notion of a colorblind constitution should be rejected. And Justice Sotomayor specifically stated that the majority was attempting to cement colorblindness as a constitutional principle. However, the Constitution is not and has never been colorblind. While it may not specifically mention race, in its context, I think we all know that in the Constitution, slaves, i.e. African Americans, were identified as 3/5 of a person and were not, in fact, equal persons at the time of the writing of the Constitution. Justice Sotomayor also specifically discusses the expansive language in creating the Equal Protection Clause and its rejection of colorblind proposals, because part of the Equal Protection Clause actually came out of the race-conscious nature of the 14th Amendment, particularly as it relates to other laws that we had on the books, such as the Freedmen Bureaus Act, the Civil Rights Act of 1866. We had another Civil Rights Act of 1970, and all of those confirmed that the Equal Protection Clause permitted racial consideration to achieve the goal of equality. Next page. Justice Sotomayor also in her dissent criticized the majority for abandoning 4 decades of precedent. As if you will recall, at the beginning of this presentation, I indicated that it was quite a surprise that they decided to take up affirmative action as quickly as they did once the new majority was cemented on the court. And because the new majority was cemented and they did take up this case, obviously they abandoned the precedent that had been set since the Bakke case. She affirmed and reaffirmed that the Equal Protection Clause authorizes a limited use of race in college admissions for the benefit that allows that comes from a diverse student body. For example, I come from a rural town. I'm a Black woman from a rural town in Louisiana. I ended up going to Tulane University, which was obviously in a city. A lot of people, it was probably about 20 to 30% from Louisiana, and then another probably 15 to 20% from Texas. And then everyone else was from everywhere else around the country, and indeed some folks from around the world. And so we had lots of differences of opinion. The school was 30% Christian, 30% Jewish, 30% other religions, or 40% other religions. And so we did have a very diverse student body, and those ideas were present in all of our classrooms. Justice Sotomayor specifically discussed whether or not a diverse student body was a compelling interest, and she identified that that particular compelling interest of having a diverse student body was rooted in the principle of academic freedom and the First Amendment, and that there was nothing in the precedent that required precise interests to be found compelling by the court, i.e., the court itself could determine what is compelling. And she specifically stated that Harvard and UNC already knew that they had racial inequalities built into their system because of their histories, both of which engaged in the slave trade, and that it was built on a legacy of slaveholding, and that this was their attempt to try to root out racism and provide a more equal society and diversify their broader population of their student bodies. Because obviously, if you're considering legacy status as the number one criteria for admitting students, if Black persons weren't allowed into the school until the 60s, 70s, 80s, then you could not really have a legacy status except for maybe with the exception of one generation. Next slide. She warned of the negative consequences for Black Americans and the broader democratic systems. If you read the actual opinion, I don't have mine here, but I have it nice and tabbed and bound because I'm a nerd like that. I like those kinds of cases. It shows that the language is very broad in the case and that it can be applied to several different areas of life. And indeed, we do have, which we'll discuss in a minute, several cases relating to race as a consideration in multiple areas of life in the country, not just education. You'll see they talk about it with government-run programs and jobs and labor and employment. And Justice Sotomayor specifically discussed that race consciousness in admissions is imperative to providing effective public service, leaders in politics and business, and a diverse legal profession to ensure the justice system. And I'll get into in a few minutes when we go later why it's particularly important in certain public services, for example, in the healthcare system, which is what I do. I do medical malpractice. And you can see some cases, for those of you who don't know, particularly in the labor and delivery area where Black women die at a rate in certain states 2 or 3 times higher than white women, and how it might be affected and lowered if they have a doctor who understands some of these different issues related to a diverse population. And they, of course, would understand that more by having a diverse peer class when they're in med school. And she continued that increased representation of minority students led racial stereotypes to be actually reduced, because when you are exposed to other people, you realize that the stereotypes you have in your head about someone are not necessarily what they're actually like. And so you find out that they're ordinary human beings just like you, and what you think or what you see on TV is not necessarily the truth about that particular person or that group of people. You know, you always hear, oh, this Black person is so articulate. Well, you know, one of the ways that you get rid of that implicit bias or outright bias is by being in courses or classrooms with Black students that all are quote unquote articulate or speak the same way as you. Not everyone speaks Ebonics or rap language. And so increasing the representation of minority students would help cure some of those stereotypes rather than reinforce them by not having those students there. So next, let's talk about the Jackson dissent, which was a masterful piece of writing. If you're like me and you love legal writing, I highly recommend you read this. Also, as a personal aside, I love the writing of one of our own magistrates here in Louisiana, Mike North in the Eastern District. I suggest you read some of his opinions. They're amazing. If you're someone like me that loves legal writing, both Judge North's and Justice Jackson's opinions are always amazing. She specifically criticized the minority for detaching itself from America's history. And she says that the majority looks at race consideration in a vacuum, like it did not have a history of slavery, a history of Jim Crow, a history of segregation, those kinds of things. And those are the reasons why we currently have a race-linked gap in our educational system. She employed historical examples of racial preferences to show that the country's never been colorblind. And in fact, there was a racial preference built into the country for Caucasian and white people rather than Black people. And now that the script, or Hispanic people or Asian people or Native Americans, and now that the script is flipped and we are trying to give not even necessarily a benefit to everyone, but just making it a consideration in the holistic view of the application of a student trying to enter college, that now it's no longer okay. She gave a specific example of James, a Black university candidate for UNC, who would like to go to UNC and has to write an application about, write an essay about why he wants to go to UNC. And John, in the same situation, however, John is a white applicant who has 6 generations of legacy status because his grandfather was able to go to UNC in the 1800s. And James, who doesn't have that same legacy status, if you can't consider his race, would no longer be able to discuss that. And I'm pretty sure that's why, because of that unique questioning and reasoning that she brought out, why the majority created a carve-out, indicating that while race couldn't be considered in the application, that a minority student could write about the effect of race in their essays to the school, which is problematic in and of itself as a person of color, to have to say that I can only discuss race in an essay. That means if I'm ever going to have my race considered, or any issue, whether it's a disability or something like that, that I have to pigeonhole myself to just my racial issue. What if I really loved AI and robotics and I wanted to write about that, but now I'm pigeonholed into writing an essay about my race? Next slide. This is probably the most powerful quote from Ketanji that Jackson, that most people picked up on, and I'm going to read it just because I do think it's powerful. The majority seems to think that race blindness solves the problem of race-based disadvantage. But the irony is that requiring colleges to ignore the initial race-linked opportunity gap between applicants like John and James will inevitably widen that gap, not narrow it. It will delay the day that every American has an equal opportunity to thrive, regardless of race. And I think she's probably right on that point.
Thank you so much, Val. So now we're going to get into the SFFA decision. Right? So, okay. So, needless to say, the court's SFFA decision emboldened a lot of conservative groups and a lot of conservative attorney generals who are anti-DEI. Attorney generals of 13 states on that list issued a warning to the CEOs of Fortune 100 companies threatening serious legal consequences over race-based initiatives. So everybody knows, or everyone should be aware, that after the murder of George Floyd in 2020, a lot of Fortune 100 and 500 companies created diversity, equity, and inclusion positions, programs, fellowships, and law firms did the same in an effort to promote and increase diversity within those professions. And so, for whatever reason, those companies, we're seeing that they are getting rid of those initiatives and also getting rid of some of their DE&I officers and teams. For it also, some conservative groups, such as the American Alliance for Equal Rights, have sued some of these companies, as well as some law firms over their DE&I initiatives. All right. So, again, the American Alliance for Equal Rights, they are suing 2 international law firms for its DE&I initiatives. I believe been dismissed because the law firm actually agreed to get rid of their diversity fellowship, which is unfortunate. As I said earlier, the law firms and corporations, they are altering those initiatives out of fear of facing potential litigation. So what are the questions, right, is the court's SFFA decision deals with the public sector, right? These corporations are private corporations. So why in the world the court's decision does not apply? Arguably, it doesn't apply in the private sector. It only applies in the public sector. Why are these corporations running scared, right? I mean, my guess is that those companies, one, do not want to face the cost of litigation, so they're willing to back down. They may have some clients, some conservative clients, right, who are threatening to pull the business. Now, I don't know what client that may be, because most clients that I see, they are dedicated to diversity, thankfully. But I'm sure there are other clients who may not be, and they may threaten to pull the business. Maybe those companies, to begin with, they were not very supportive of DE&I initiatives. So this is kind of a scapegoat for them. It's easier for them to get rid of those DE&I initiatives. And Val, I think an important thing, or an important point that I want you to touch on, is what Chief John Roberts said in relation to college admissions and the military.
Right. So if you read the majority opinion, you will see that they, of course, say that race can no longer be considered as a factor in determining whether or not an applicant will get into the school. However, it could still be considered in other areas of federal life, such as the military. And ironically, hot off the press, in earlier this month, February 2nd or 12th, I believe, SFFA sued on behalf of students at West Point, stating that they were illegally using the consideration of race in determining who would be admitted to the college, a military academy. Those of you who don't know, we have 3 military academies. We probably have more, but I know of 3, which is Annapolis with the Navy, VMI for the Marines, I believe, and West Point for the Army. And and the Citadel. So there's 4. And that I know of. If you're in the military, I apologize. I'm sure there are more. But that's the ones I know off the top of my head that are actual colleges where you go to college first and then enter the service afterwards. And the Supreme Court specifically did not take the case up. They did not want to reconsider the issue. And so military academies are still allowed to use race in their admissions, as the court determined they may have potentially distinct interests. Now, how their interests are potentially distinct versus UNC or Harvard based on only those 2 considerations, one of which you'll remember was about prison race riots, I'm not sure, because arguably the compelling interests or distinct or interests of both West Point and our military academies in considering race would be the same for any other public educational institution, or even a private educational institution, because private educational institutions still receive public funding from FAFSA. So that's one that made me go, particularly earlier this month when the Supreme Court decided to not take it up, because I don't know how you justify one versus the other.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.